Good morning and welcome to the inaugural event of the Tye Center for Law, Science, and Innovation at the SMU Dedman School of Law. This inaugural event is entitled the Symposium on Emerging Intellectual Property Issues, the Future of Innovation in Intellectual Property. My name is David Taylor and I'm an assistant professor of law here, and along with Keith Robinson, I serve as one of the co-directors of the Tye Center. In a few minutes, I'll provide some additional opening remarks. But first, let me introduce one of the people most responsible for the establishment of the Tye Center here at SMU, the Judge James Noel Dean and Professor of Law Jennifer Collins. Dean Collins received her undergraduate degree cum laude from Yale and her law degree magna cum laude from Harvard Law School, where she served as an editor on the Harvard Law Review. After law school, she clerked for the U.S. Court of Appeals for the Ninth Circuit and then worked in various legal positions in Washington, D.C., including serving as an assistant United States attorney for 8 years, where she worked for 6 years in the homicide division. She later was a professor at Wake Forest and served in the provost's office at Wake Forest immediately before joining the SMU Dedman School of Law as our dean. So join me in welcoming and thanking Dean Collins for her efforts in establishing and supporting the Tye Center.
Thank you so much for coming today, and welcome to the inaugural event for the Tye Center for Law, Science, and Innovation. This is an incredibly exciting day for the SMU Dedman School of Law, and we are so thankful that we have so many distinguished jurists, attorneys, community members, law professors, and students here to celebrate this remarkable day for us. The center was created as a result of a $3.125 million gift, which included both operating funds and endowment, from an extraordinarily generous donor who wishes to remain anonymous. We hope at some point in the future we will be able to convince our donor to step forward, but for the moment wishes to be anonymous, which is why you are not hearing more about the donor. But please join me in thanking this very generous individual who made today possible. We are so grateful. The center's mission is to be a research-focused academic center exploring how law and policy affect scientific research and discovery, as well as the development and commercialization of new technologies. The center also explores the converse, how scientific discoveries and emerging technology affect ethics, policy, private industry, government regulation, government policies, and the like. So needless to say, our range of issues that we hope to address is very broad. We plan for the center to present educational programming, facilitate academic research, and provide educational opportunities both for our students and for the academic and business communities. In short, the center exists to engage the public, scholars, students, scientists, policymakers, and innovators in considerations of the most pressing questions of science and innovation in our time. We are so fortunate to be located in the great city of Dallas. I can't imagine a better place, other than Silicon Valley maybe, to be launching a center like this, because being in Dallas gives us opportunity and access to work with such a wide range of organizations, from the art, science, and engineering programs at SMU, to other local universities and medical schools, to various technology incubators and accelerators, and to the Dallas Regional Office of the U.S. Patent and Trademark Office. We look forward to collaborating with all of you on the center's projects and initiatives in the years to come. There are some very hardworking individuals I need to thank for making today possible. I'd be grateful if you could join me in thanking Rebecca Bell, Lynn Dempsey, Christy Offenberger, our 2 student Tye Center Fellows, Alex Bridge and Kristen Zanow, our amazing IT staff who is live streaming this to another room where many of our students are sitting today, and the student members of the Intellectual Property Organization who got up very early on a Friday to make the logistics work today. Could you join me in thanking all these individuals? But most important, I need to thank our 2 wonderful co-directors of the center, David Taylor and Keith Robinson. One of the amazing things about both of these individuals is that they are still pre-tenure. It's a lot of pressure to be pre-tenure. Yet they have given so generously of their time and energy in making the center come to fruition. From me calling them right before a weekend and saying, hey, I have a donor who has this idea. Can you write me up something really, really fast about what you would like to do with an academic center? So they are responsible for helping to secure the gift. They're responsible for all the efforts that are going to bringing together a wonderful executive board and advisory board, bringing the symposium today and all the wonderful programming and events that are going to be taking place in relation to the center in the future. They, together with their other colleagues on the executive board, many of whom are in the room, Nathan Cortez, Lack Bloom, Megan Ryan, I haven't seen Professor Mayo yet, but I'm sure he'll be here. All of these faculty members give so generously of their time and energy to bring this together. I hope you will join me in thanking all the members of our executive board and our co-directors, David Taylor and Keith Robinson in particular. They are remarkable scholars and teachers, and I am profoundly grateful for all they have done for the law school, the academy, and our community in bringing the center to SMU. Please join me in thanking David and Keith. You have a very full day of programming ahead of you, so I am going to step aside. David Taylor is going to be your master of ceremonies for the morning events, so please enjoy. Let us know if we can help you in any way with your experience today. We're so glad you're with us.
Thank you, Dean Collins. I do have some administrative announcements real quickly. I want to encourage you to follow the center. We have some social media accounts, so at SMU Tie Center is our Twitter account, and we also have a Facebook page, facebook.com/SMU Tie Center. You can find out more about all of the different events that we're going to hold this year and going forward at the Tie Center. And we actually have a hashtag for this event if you are interested in using Twitter, hashtag Tie Emerging IP. So encourage you to use that. And check out, by the way, we have, of course, a page on the SMU Law School website. Encourage you to check that out with additional information about the center itself and about its activities. And if you want to use Wi-Fi to get on Twitter or Facebook, I'm sure that's what you'd be using it for. But anyways, I understand there's information about how to get on the law school's Wi-Fi network out at the registration table. And for those of you that are attorneys and want to get continuing legal education credit, we have information about that out at the registration table. The last thing I want to do before introducing our first speaker is give a brief overview of the symposium. So as I mentioned, the theme of this year's symposium is the future of innovation and intellectual property. Of course, innovation is the use of technology in the marketplace. Intellectual property, of course, includes patents, trademarks, copyrights, and trade secrets. But there are rights to exclude, right? And the idea behind the government recognizing these rights to exclude is that they facilitate invention and creation. It's important to recognize, however, that the relationship between innovation and intellectual property is at least disputed, and perhaps more so today than in a long time. In particular, it's disputed whether the intellectual property system is necessary or even helpful to encourage the use of technology. Some would even say that intellectual property in some cases impedes rather than furthers innovation. So I hope that's one topic that we'll explore today. And exploring this topic, I also anticipate that we will consider how the law governing intellectual property and its enforcement might be improved to allow for and indeed to encourage innovation. In other words, not just the mere creation of technology, but also its use in the marketplace to improve products, to improve services, and ultimately to improve the human condition. So to that end, we have a full program, and we're going to start with our first keynote speaker of the day, who is retired Chief Judge Paul Michel of the U.S. Court of Appeals for the Federal Circuit. So let me give him an appropriate introduction. So he was appointed to the United States Court of Appeals for the Federal Circuit in 1988. He served on that court for more than 22 years until 2010, including 5 years as Chief Judge of the court. In his years on the bench, Judge Michel judged thousands of appeals and wrote over 800 opinions, approximately a third of which were patent cases. Prior to his appointment on the bench, Judge Michel served in the executive and legislative branches of our government for 22 years, the same number of years he served as a judge on the court. Following graduation from Williams College and the University of Virginia Law School, he served as an assistant district attorney and then deputy district attorney for investigations. He served as an assistant special Watergate prosecutor He was assistant counsel for the Senate Select Committee on Intelligence. He was the deputy chief of the Justice Department's Public Integrity Section, where he directed the Korea Gate investigation. He was an associate deputy attorney general, an acting deputy attorney general, and just before he joined the bench was on Senator Arlen Specter's staff, where he served as counsel and chief of staff. So he has a distinguished resume in terms of his government service. He's also received numerous awards and recognitions, and there's too many to name here, but including numerous, in fact, lifetime and career achievement awards by different groups, such as the Richard Lynn American Inn of Court, the Sedona Conference, and by some magazines like the Managing Intellectual Property magazine, as well as different attorney groups like the American Intellectual Property Law Association and many, many others. Since retiring from the court in 2010, Judge Michel continues to speak out on issues related to the courts and the patent system. He provides mediation, arbitration, case evaluation services. He serves as well as an advisor to a number of U.S. and worldwide intellectual property organizations, including, for example, the Intellectual Property Owners, the IPO Education Foundation, the American Bar Association, the World Intellectual Property Organization. So with that introduction, please now join me in welcoming Chief Judge Michel.
Thank you very much, David, and thank you to all of you for being here. This assembly represents exactly what policy debates in our country should reveal, and that is the enormously important, valuable input that can come from people of diverse disciplines and experiences. As the Dean mentioned, we have here students, litigators, people from industry, academics, and many others. And I think the cliche wisdom of the crowd is on steroids when we talk about wisdom of the experts. And every one of you is an expert in something relevant to policy for innovation in this country today. So we've got the right people in the room, and we're going to have, I think, a very fine experience here today. I want to start by explaining very briefly why I retired. I absolutely love being a judge. I had originally planned to stay until life was over and I would get carried out of the courthouse in a pine box with a smile on my face at age 93 or something like that. I changed my mind as my time as the chief judge came to its end, because there is an age limit of 70 for chief judges to continue serving in that role. It's a very good system because it means there's a steady turnover of chief judges in all of the courts of appeals. But the real reason, the main reason, was that for good and proper concerns, sitting judges are quite restrained in what they can say on political issues, public policy issues, broad concerns that go beyond simply judicial administration. So in a sense, I retired in order to regain my First Amendment rights. So I'm now a self-appointed public scold. So I go around criticizing Congress and the Supreme Court and the White House and anybody else that I think is not being helpful to the future of the country and not helpful to increasing the health of the innovation system that has got this country to where it is today. So really, retired is a misnomer. I'm busier than ever. So at age 74, I normally get up about 4 o'clock in the morning to start my working day because I got so many things I'm trying to juggle. But nothing that I do is more important than speaking with men and women like those of you here in this room. So I'm really, really thrilled to be here. Now, as I've suggested, you all are experts. But in addition to knowledge, I think you have an important role, an important responsibility with respect to the larger discussion, conversation, debate, whatever we want to call it, that's raging in this country, not only on Capitol Hill, but in the general press and the legal press and the academic literature and the economic literature and on and on. So let's contrast you, experts in various particular disciplines, with the policymakers of our country. The members of Congress, 535 men and women, hardworking, intelligent, elected, representing us, democratically chosen, but they're not experts. They don't understand how the IP system works. Supreme Court, not much better equipped to understand the workings of the larger system, because it's not just cases, it's not just disputes that are adjudicated. The hand of the system reaches far beyond that. Same thing with the people in the White House. They're not really experts either. So the people making all the decisions actually know the least. You actually know the most. So I'm trying to promote some kind of coming together here. Now, this conference focuses on the future. Of course, it is always difficult to predict the future. I won't try to predict the future, but I will concentrate on some hints about the future by focusing on the very recent past. I consider that the country is at a major crossroads with respect to innovation, invention, intellectual property, investment, R&D, commercialization, and all the related matters. We have a choice. We can either strengthen the existing system we have, or we can pretty well take it down. That's the stark way to put the choice. I think it's entirely possible that before the end of this decade, we will actually take it down. On the other hand, we could preserve it, and we can even improve it. That's the other fork in the road. Now, the thing we should focus on is how complex the innovation system is, because it involves inventors, investors, litigators, patent prosecutors, examiners, trial judges, appellate judges, business leaders, economic analysts, and on and on and on. It's a very large, very complicated system. Now, in Washington, there's a famous saying, which I think applies to understanding how the system works, and that cliche is, follow the money. Wherever the money goes, that tells you a lot about what's going to happen next. Therefore, I think the most important thing about the larger innovation system focuses on investment, on incentives to invest in research and development and the follow-on commercialization. Now, if the system is half as complicated and far-reaching as I think it is, and a lot of it has to do with money and not only science and technology, then I suggest the two most important things are reliable facts and reliable numbers. Facts and numbers, and I'll come back to that many times, as you'll see. Now, I'm suggesting that the patent system particularly exists less to incentivize inventors than to incentivize investors. It really is all about the money. So I submit that investment is almost in direct proportion to the attractiveness of the incentives, the chance of getting a good return on the investment. And that's true whether it's an investment with outside money, like a venture capitalist supporting a startup. It's equally true for a giant company that has a huge revenue stream, and it has choices about what to do with the revenue stream, how much to invest in R&D and how much to invest in stock buybacks or dividends to stockholders and so forth. So all investors have many options. Now, investing in invention is inherently risky because most inventions fail. Most startups fail. Most new products fail. Most drugs candidates fail. So it's inherently risky. And not only that, but it's sizable. R&D is costly, but commercialization is vastly more costly. When you're going to build a factory to produce a new product and you're going to hire workers and you're going to set up a distribution system, it costs enormous amounts of money. So the investments needed to spur the cycle of R&D leading to new products, leading to commercialization, leading to growth in the economy is a very complicated dynamic. And the thing to remember is it not only takes investment, and a lot of investment, but it takes repeated investment. So any given small, emerging, innovative company has to go back to the funder's well over and over and over. And every time they have to ask for even more money because that's the way the cycle works. So the incentives have to be pretty high to get the innovator all the way down the track. Now, one thing that is easily lost in the debate is the importance of early stage invention and small and emerging companies. Not only startups, but things that used to be startups that are now growing fast. There are some very interesting studies, 2 by the Kauffman Foundation and 2 by the Census Bureau that I know of, and I believe there are others as well, that seem to support the idea that for the last several decades in America, nearly all net new jobs were created by startups and emerging companies that were commercializing new technologies. That's a very important thing to remember, because in our political system, they who are small don't have lobbyists, don't have lawyers, don't have PR firms, don't make big campaign contributions, aren't highly mobilized, aren't highly organized, and therefore there's a risk in our system that their voices are not well heard or even heard at all in the halls of Congress. So that's a dynamic we will explore a little bit as we go along here. Now, it's my submission that patents are an important means of boosting the assurance of adequate return on investment. They're not the only thing. Sometimes market forces are perfectly adequate by themselves to spur investments of the sort we are discussing. But I submit that in a great many cases, I even want to suggest maybe most cases, patents are an important part of the picture. So the strength of patents and their enforceability has considerable import. Now, my friend Judge Posner and I had a debate in which he said, well, so much invention would occur even without patents. Why do we really need patents, at least outside of big pharma, where the timelines are so long, decades, and where the amounts of money run into the hundreds of millions or billions? And I think the answer is, at least my answer is, well, it depends what outcome you want. Sure, you could get rid of the patent system by and large, except for some selected sector like pharmaceuticals. But are you prepared to live with half the value, half the innovation, half the growth, half the new job creation? Now, of course, I can't prove it's half. I'm just stipulating a number. But I don't think any of us would be willing to settle for half the growth, half the job creation, half the prosperity that we would have in that sort of a patent system. So I end up saying, I think a patent system that's designed to work for all companies, all sizes, all ages, all technologies is the best approach. It's not easy because sometimes there are conflicting forces between and among various companies and technologies. But still, I think it's the right overall goal. Now, when we look at things from the standpoint of the perspective beyond the borders of our country, we have to ask ourselves, well, we can't compete with cheap labor countries in our present global economy. So much of the prospects and potential for future growth involves overseas markets. And we can't compete very well, for the most part. There's some exceptions, but for the most part, with cheap labor countries. So what is our competitive advantage with all our commercial rivals? Our competitive advantage is we're the best innovators on the planet. and we have been for decades and decades. And I hope we will continue to be, because I don't see another engine of growth and prosperity that's anywhere near as good. So let's ask now, how are we doing now? Not the long history, not even 5 or 10 years ago, but how are we doing now? I'm going to define now essentially as the last 2 to 3 years. In the 80s, in the 90s, and at least up until the middle of the last decade, prosperity growth, innovation growth was fabulous overall. It's stalled a little bit, in my opinion, in the latter half of the last decade, but I'm particularly focused on just the last few years. So what is the picture that's emerging? From what I'm told, from what I read, from what I understand, there are many, many technologies and companies in which investment is falling instead of holding steady or hopefully growing. There are many, many technologies in which licensing that was very active before is now falling off sharply. There are many companies and technologies where investment and licensing is almost totally stopped. Now, it used to be, back in, let's say, the 90s, that we had in this country what I call the honor system, and that is that most commercial actors, most companies, honored the IP, particularly patents, of other companies. And so they negotiated and took licenses, usually with very limited or even no litigation. So, for example, my friend Marshall Phelps ran the licensing program at IBM in the 90s. That program netted IBM billions of dollars per year, and at a low ebb of IBM's up and down fortunes over the decades, it was the principal source of profits for IBM in the lean years when they had to restructure. Marshall Phelps said they never had to litigate a single case. So they can make $2 billion a year in licensing fees without having to sue anybody. Why? Because we had the honor system. Now, I'm sorry to report that as far as I can tell, the honor system is largely gone. Not totally, but largely gone. That's a huge change. As a result of that, there are many companies whose growth is stalling out, many companies where they're actually shrinking, not growing, where they're laying off workers, not hiring new workers. Some companies are dying. There are many reasons. We just came out of an endless recession, as we all know. But one of the reasons is that for causes we'll explore briefly, patent values are falling. Individual patents, patent portfolios, patent-dependent companies, the economic value is falling. Well, why is that? Well, I want to suggest it's mainly, there are many forces, but mainly two. The impact of the AIA post-grant reviews, particularly IPRs, inter partes reviews, and the impact of multiple Supreme Court decisions, starting out a little slowly, a little modestly in 2006 with eBay, 2007 KSR, and then growing with Bielski, and then particularly with Mayo, Myriad, and Alice. Seismic impact. Whole industries where the patents now are probably worthless. Massive uncertainty in all those industries, companies, or technologies under the cloud of invalidation because of what I'll call the Alice regime. Now, there are other causes, too, and they're worth briefly mentioning. One is the extent of uncertainty created by not just the AIA, but the new wave of legislation pending floor action in both the House and the Senate. Whatever its merits, it adds to the already huge amount of uncertainty. In my retirement stage, I've learned a great deal about business and economics and investment, and it is almost uniform. If I've talked to 1,000 people, at least 900 of them have told me systems can adjust, companies can adjust, CEOs and other leaders can adjust to almost anything except uncertainty. The more uncertainty there is, the worse it is for investment, for innovation, for growth, for prosperity, for technological advance, and all those related things. So one of the biggest problems right now is we have a sudden surge of massive, widespread uncertainty. That's a very big problem. I guess the watchword for people in the investment community is, when in doubt, don't. If there's adequate insurance, maybe, but when in doubt, just don't do it. Now, some people hear me tout the accomplishments of the IP systems, and particularly the patent system, and defend its utility for our economy, for our country, for our global competitiveness and internal social health, economic health. You know, it's not an exaggeration to say that national security, and in the age of terrorism, we talk a lot about national security, depends, and even the military leaders say this, more than anything else, on economic security, on prosperity, on growth, on global competitiveness. So this is a big deal. This isn't just for, patent nerds on the Federal Circuit or in some law firm. This is really something that affects all Americans. So people think, well, Michel is just a defender of the status quo and everything that's in it. No, I'm not. I think there clearly are abuses. There are bogus demand letters that are sent out, sometimes by the thousands, by certain irresponsible parties. There are some lawsuits that are frivolous as filed, or that are frivolous and abusive as actually litigated. I absolutely support patent reform if it means targeted, balanced efforts to curb bad behavior, counterproductive behavior. I'm not against patent reform, and I'm not against the goals of the two pending bills. I think the bills themselves, however, in their present form, will do a lot of harm and actually, ironically, a very limited amount of good in combating the so-called trolls. So we have to start focusing again on facts and numbers. First of all, definitions. Who is a troll? Well, on Capitol Hill, it's assumed that a troll is anybody who isn't producing a product. To me, that makes no sense. A troll is an abusive filer of demand letters or lawsuits, or an abusive litigator of lawsuits. But a responsible party who has a real suit shouldn't be called a troll. That's just name calling. That's just goofy bumper sticker sloganeering. That's not intelligent analysis, in my opinion. So not every non-practicing entity is a troll, far from it. And in fact, abuses are sometimes committed by accused infringers. It's not only patent-owning plaintiffs who can abuse the system. So we have to realize the complexity of the problem. So when we get past who, it's important to understand how many. How big of a problem is this? Is this a 2% problem, a 20% problem, an 85% problem? It makes a huge difference. But in Washington, they apparently can't count, because there's almost no serious discussion that's based on numbers or actual proofs. It is asserted that there's a litigation explosion, that it's costing American businesses $29 billion a year, $83 billion a year, some other number that, as far as I can tell, more or less pulled out of the air or based on assumptions or kind of wild speculation. So numbers are important, but they have to be dependable numbers. They have to be honest numbers. They have to be fair numbers, the best that good analysis can come up with. So not only frivolous lawsuits, but invalid patents are a problem. There are too many invalid patents. There is a serious error rate problem in the patent office. I might note, however, that the errors go in both directions. Examiners reject applications they should grant, and they grant applications they should reject. So it's not all in the direction of too many patents. the Supreme Court justices in oral arguments like to say things like the PTO is patent happy. And other justices say the Federal Circuit doesn't understand the basics of patent law. It's a little hard for me to accept either of those statements, but that's another matter, I suppose. So we do have a problem of invalid patents, and the AIA reviews were a good experimental mechanism to try to get rid of bad patents, particularly ones that are in court. I think it was a good try. Experience suggests, in my view, that it needs some adjustments, but not abolition. It really needs to be strengthened. And enforceability needs to be strengthened too, in my opinion. So again, numbers. What is the error rate in the patent office? And how much does it vary by technology? And what can be done about it? And I'll come back to that. But you know, even the debate there tends to degenerate, in my opinion, to what I'll call stupid slogans. So for example, I hear endlessly about, quote, low quality patents. Low quality patents are rampant. The patent office is issuing thousands, millions of low quality patents. I don't know what a low quality patent is. I know what an invalid patent claim is, but I don't see how you can meaningfully discuss patents in terms of quality. A given claim in a given patent is either valid or invalid, and it really isn't very helpful to talk about quality. And beside that, I saw by rough estimate over 2,000 patents in 2 decades on the Federal Circuit and helped adjudicate disputes involving those patents. It's my firm recollection that in most cases, the patent wasn't valid or invalid. Particular claims were valid or invalid. And in the majority of cases, there were some of each. There were some claims that were absolutely rock solid valid, and others that were pretty questionable, and often some that were pretty definitely huge overreach. So we shouldn't be talking about bad patents, low quality patents. We should be talking about validity and particular claims if we're going to have a really useful debate. At least that's my suggestion. Now, frivolous lawsuits, like the error rate in the patent office, is something that ought to be able to be measured, and some scholars, and Professor Lemley here with us today is an example, have done quite a lot of work using empirical data, which I think is much to be commended and encouraged and supported, because that can yield reliable facts and statistics, reliable numbers. And I think the key to success, to optimizing our system, both to curb abuses and to promote innovation, comes down to having good facts and good numbers and then doing the logical analysis therefrom. So how many of the lawsuits are frivolous? We get 5,000 or 6,000 a year nowadays filed. How many are frivolous? Well, as far as I can tell, no one knows, because 95% of them are settled or dropped. So there's never an adjudication, so you don't have a black robe person saying whether it was frivolous or not. I'm sure some were, but of the non-adjudicated cases, we only adjudicate several hundred cases a year in this country. We try about 100, roughly speaking, and we have summary judgment or dismissal or other such disposition of several hundred more, 300 or 400 in all. So out of 5,000 or 6,000, only 400 get adjudicated by judges. All the rest disappear in one fashion or another. As far as I know, nobody has any good handle on what the percentage is of those that are frivolous. But it would be important to know. If 1% of them are frivolous, you've got a problem. If 8% are frivolous, you've got a problem. If 55% are frivolous, you've got a crisis. So which is it? Nobody knows. So how can you calibrate a solution to a problem if you have no idea of its scale? So that's one of the challenges. So much study is needed. My impression from the patent disputes I saw was that fewer than 1% of the appeals, not filed lawsuits, but of appeals, were arguably frivolous, less than 1%. Now, at the trial level, it's probably a higher percentage. I don't know what it is. maybe Judge Hochberg and others who will speak later could give some kind of rough impressionistic number. But again, empirical research would be better than impressionistic numbers. But let's assume that 10% of the cases filed in district court are frivolous. 10% is not an insignificant number, but I don't think it's a crisis either. All systems have error rates in every walk of life. There is no perfect system. All systems can be abused. All systems are abused. But the question is how bad, how often, and in what manner, and what can we do about it to try to limit it? We'll never eliminate it 100%. But if we can get it down, if we have a 30% problem and we can get it down to 3%, that's about as good as it can be, and that's what we should be striving for. Everywhere you turn in the policy debate about patents, you hear slogans. So, for example, it is said 8,000 times in the last 3 years that America is suffering a, quote, litigation explosion. That's very scary, just like the word patent troll is a very scary slogan. Well, it's certainly true that the number of lawsuits filed has gone up over the last 10 years or so in a very significant fashion. On the other hand, looking back historically over the last 150 years in this country, roughly speaking, about 1.5% of patents then in force get litigated. So most patents have no commercial significance, at least in terms of being litigated. And I mentioned earlier, I think, the other slogan, the tax on innovation. These slogans don't have numbers, and numbers that aren't reliable aren't helpful. So if we look at some other numbers, we get some hints, not real conclusions, but some hints. So for example, when we try to focus on how many lawsuits are frivolous, of all the lawsuits that are filed and move past the first stage or two of the litigation process, in most cases, fee-shifting motions are never even filed because even the winning party doesn't think the other side was engaging in irresponsible filing or behavior, litigation of the case. Of those where the motion is filed, how often are they granted? Well, pre-octane, in the neighborhood of 15%, post-octane, upwards of 50%, around 45%, as I recall. So octane's made a significant difference. But still, the overall picture doesn't support the idea that most lawsuits are frivolous, at least to the extent that we look at judicial frivolity rulings as a proxy for the quality of the suits. Now, if I'm suggesting, which I am, that the frivolous lawsuit, tax on innovation, litigation explosion rhetoric is overblown, and they aren't colossal problems, they aren't a crisis, they are serious, they need attention, not a crisis, then what are the serious sub-optimizations of the system currently? Number one, affordability. Of all people who can and do own patents, how many can afford to enforce them in court? If I'm right that the honor system is largely gone, then a patent is not a legal right that works in commerce. It's little more than a piece of paper which you could call a ticket to sue for infringement in the district court. So who can enforce? Kevin Rivette, who's in the economic side of patents, which I am not and have not been, says frequently and publicly, and I assume he can back it up, that to enforce a portfolio today, not 10 years ago, not 20 years ago, today, a company needs a war chest of $300 million in available cash and a market capitalization in the billions. Now, maybe that's in itself an exaggerated set of numbers. I don't know. But it raises a question of if it's anywhere close to that, that means that we are approaching a point where patent owners cannot afford justice, cannot monetize valid patents that are actually being infringed. Assume that with me. So that means almost no startups can enforce valid infringed patents. Almost no universities, almost no research institutes, almost no hospitals, almost no university spin-offs, almost no small emerging middle-sized businesses, almost all national labs and private labs. So who can, in today's world, really afford to enforce valid infringed patents? The Fortune 100, the Fortune 200, the Fortune 300, I don't know. You can do the math. You can sort of see the cutoff. But a very small portion. In America today, we have several 100,000 commercial entities. If we limit our view to those commercial entities that employ at least 100 fellow Americans, that number comes down to 30,000. The drive for what I'll call radical patent reform is being led not exclusively, but primarily by 50 companies. So out of 30,000, 50 companies seem determined to have a very substantial weakening of the patent system. Well, they're entitled to petition the government for redress of their grievances. They spend a lot of money on defense. Sometimes they spend a lot of money on adverse judgments. They have an enormous influx of demand letters and a smaller but still burdensome influx of district court complaints. If I were at one of these companies, I would be lobbying Congress too. I'd be trying to reduce my costs, litigation costs, judgment costs, staff diversion costs, and all the rest. But if the system is going to serve everybody, all companies, all technologies, all sizes, it has to work as well as possible for the other 29,950, not just the 50 megatech companies and retail allies. Now, I talked about Kevin Rivette's estimate of how much money you need, but consider more specifically. It is said, I think reliably, that litigating to conclusion a patent lawsuit today costs between $3 and $10 million. So just take that as a given. It is also said that for most IPRs, in significant cases at least, the cost runs between $500,000 and $1 million. In most cases, a commercially valuable patent is challenged in more than one IPR. So this means the patent owner is going to have to spend $3 to $10 million in the courthouse and $1 million or $2 million in the patent office to defend the patent on review. So that's a lot of money. If we look at the cost in time, the current delays are in the neighborhood of 3 years to verdict, usually followed by up to a year for post-trial motions, usually followed by about a year on appeal. So we're talking about 5 or 6 years or something in that neighborhood before considering IPRs. Now, in most cases, the accused infringer, quite sensibly and understandably, is filing an IPR shortly after being accused of infringement. And most district judges, quite sensibly, quite understandably, are granting stays, usually indefinite stays. So now there's a 3-year timeout of the district court litigation while the IPR proceeds. And everybody says, well, wait a minute, Congress put in a 1-year deadline. But you've got to add up all the increments. There's a 6-month petition period followed by a 1-year decision period followed by the Federal Circuit appeal that always takes a year or more. So it's really a 3-year process, a 3-year timeout, not 1 year. So wait a minute, we had 5 or 6 years delay before, now we have to add 3 years. So now we're talking about a timeline of 8 years to get a final result. Wow, that's a lot. So you might spend 5 or 6 million in the district court, about 2 million in the patent office. That's in the neighborhood of 8 million. So now we're talking about $8 million in 8 years before infringement of a valid patent that's proven to be valid and infringed results in the patent owner receiving money, getting a check. 8 years, $8 million. Wow. Well, what about other countries? In Germany and the United Kingdom, patent litigation is 5 to 10 times faster and 5 to 10 times cheaper. So if we just use that as a point of comparison, we've allowed our system to become really hideously inefficient, slow, costly, and some would even say not always so accurate. Well, why are we so inefficient? Well, of course, we have very broad discovery, and it's easy to abuse, and it is often abused. We have very extensive motions practice, also often abused, easy to abuse. But help is on the way. The cavalry is riding to the rescue. The Judicial Conference, the Supreme Court, the Congress are changing the discovery rules effective, I think it's the 15th of December, and also the pleading rules, the notorious Form 18, where you could say your infringing period is out the door in December, and therefore the regime under Twombly and Iqbal will kick in, and patent complaints will have to have a reasonable, I would say, reasonable amount of fact detail in them. And motions practice is also being curbed, and abusive lawsuits are being curbed by greater fee shifting than ever before. Now, into this picture comes H.R. 9, the principal House bill, which, in my opinion, falls into the category of what I call radical reform. Radical meaning more harmful than helpful, even though there's some good things in there, and the goals are all certainly correct. So what is driving this rush to pass H.R. 9? Now that I'm free of being politically correct or embarrassing the judiciary, it looks to me like the proponents of radical reform, who have real grievances, as I've acknowledged, basically have outspent everybody else. So hundreds of millions of dollars has been spent on campaign contributions, on expensive lobbyists, expensive law firms, and expensive PR firms, mostly by the 50 aforesaid companies. So a huge amount of money is being spent. You know, it almost makes you a little bit cynical about who's trolling. I mean, maybe some NPEs, some true trolls are trolling for easy money. But a cynic would also say there are too many congressmen trolling for easy money by catering to the requests of those who have big money. So big parties with big money have big sway in Congress. So what do we need? We need a debate that's not so driven by money, that's driven, of course it'll be driven partly by money, that's our system, that's okay. But it will be driven hopefully as well by facts, by reliable numbers, by statistics, by logic, by analysis, by good economics. But when you read, as I do every day, what's the conversation in Washington, D.C., it's as goofy as the presidential primary debate. It's not really a debate. It's a bunch of name-calling, sloganeering, smearing, sneering, Hollywood on the Potomac. That's what we have in Washington now. As far as I can tell, they can hardly do anything right. You know, when you look at the hearings, H.R. 9, its principal provisions purport to micromanage district court patent litigation. So the hands of Judge Lynn are going to be tied by Congress, and discretion she now can exercise with her expertise and her experience, Congress is going to remove a lot of that discretion. They're going to micromanage cases from afar with one-size-fits-all mandates. And you know the slogan people talk about, unfunded mandates? This is an unfunded mandate. There are not enough district judges in America to handle the current system. And if we make the system more complicated, with more motions, more delays, more costs, more complexity, the shortfall of judges will hurt us even worse. So one of the things that needs to happen if we're going to have a better system is to add the judgeships in all the metropolitan districts, about a third of our 94 districts, which are badly backlogged and where judges have totally unmanageable caseloads. For 20 years, the judiciary has asked Congress to create judgeships in those districts. And for 20 years, the Congress has stalled and deferred, given a few here, a few there, always with a big lag. So every district court in a busy district is working under severe understaffing. At the Duke Conferences on Discovery, one of the big bugaboos of all complex civil litigation, including patent litigation, the Duke Conference, 2 conferences at Duke, there was a lot of disagreement, but everybody agreed that discovery abuses could be severely curtailed if district judges could manage the discovery process on a day-by-day basis. Well, hello, sure. In the perfect world, that's how it would work. In the real world, they can't possibly do that. It's totally out of the question. They've got Speedy Trial Act preference for criminal cases. They've got hundreds of motions in every one of their hundreds of pending cases. There's no way they can manage discovery in most districts, in most cases, day by day. So, let me suggest another thing. I've complained about the lack of numbers, of lack of facts, about exaggerations, about the excess influence of money. So what should Congress do, and what should we do? Well, what Congress should do is to hear from everybody. The hearings on H.R. 9 were sort of a stacked deck. It was basically the proponents of radical reform handpicked. So it's, get this is going to micromanage patent litigation in the district court. How many district judges were called to testify? 0. How many inventors were called to testify? 0. How many investors were called to testify? 0. Or a half, maybe, because somebody representing the National Venture Capital Association did testify in House. How many litigators were called to testify? I think the answer there is 0, too. So who was called to testify? The aggrieved parties, the chief patent counsel of the companies that are spending all this money and that are mad as hell about all the lawsuits and all the demand letters, and understandably so. But Congress isn't asking the right people. They aren't asking people like all of the men and women in this room, and they should, in live hearings and in other fashions. So I want to end by suggesting that we all of you, and also I, have an important role to play here to help Congress get it right, help the White House get it right, help the PTO get it right. You have the expertise, the knowledge, they don't. So my suggestion is we should all be telling Senator Cornyn and Senator Cruz, don't ram the bills through willy-nilly, fix them first. We should be telling our representatives, don't jam H.R. 9 through next week. Take the good parts, keep them, take out the bad parts. We might not all agree exactly what they are, but there's some parts that I think are plainly bad. Fix it, and then pass it. But first, fix it. Take the time to hear from all the experts. Startup business leaders are another category of missing witness. No real voice in the debate. These are the people that are creating most net new jobs for the last 4 decades in America, according to the Kauffman Foundation and the Census Bureau, and they have no voice at all in patent reform? Crazy. Academics. How many academics testified on H.R. 9? I think the number there is also 0, but I might be a little off. But you get the point. So I come back to where I started. You're the experts. The policymakers in Washington can't do this right on their own. They need input from you. They need reliable facts and numbers and good analysis. We can get patent reform right. It won't take years and years. It might take 6 months, but it's certainly worth slowing down the process to do it right rather than wreck the innovation system that the country depends on so greatly. So that's my charge to you. You're the jury. Thank you very much.
Thank you very much, Chief Judge Michel. A great way to kick off our symposium, and we're going to transition now, and I'm going to ask Mark Werbner, who I saw earlier, to go ahead and, oh, there you are. All right, Mark is sitting at the front. He's ready to go. So let me introduce Mark Werbner. So Mark Werbner is our graduate from the SMU Dedman School of Law, class of 78, so we're really proud of that. But he is one of the nation's most respected trial lawyers, and his experience ranges, right? It ranges from complex business litigation to white-collar criminal defense to catastrophic personal injury to wrongful death cases to, in fact, patent cases. But he's tried more than 150 cases across the United States. Given that most in the room focus their attention on intellectual property law, you may not realize what Mark Werbner has done. He's made international headlines. In 2014, he convinced a New York federal jury to issue liability findings against Arab Bank, and this represented the first time in U.S. history that a foreign bank was found liable for materially supporting terrorism. On the other hand, since you are focused on intellectual property, most of you probably do know that he successfully argued on behalf of a patent owner at the Supreme Court just this past term in the case of Kamal versus Cisco. And in that case, the Supreme Court vacated the judgment of the Federal Circuit, which itself had vacated a $74 million judgment that Mark obtained on behalf of his client Kamal in the Eastern District of Texas. So these are just two examples of the diverse and significant victories that Mark has achieved in just the past 2 years. So as I mentioned, he is a graduate of our law school. He graduated cum laude, with cum laude recognition from our law school, and his undergraduate degree is from the University of Texas at Austin, where he graduated with high honors. He's been recognized with numerous awards. I'll only highlight a few here. He's a fellow in both the American College of Trial Lawyers and in the International Society of Barristers. He's an advocate in the American Board of Trial Advocates, and he was named the Trial Lawyer of the Year in 2011 by the Dallas Bar Association. So I could go on, but I'll stop there. Without further ado, I want to introduce Mark Werbner. So as any good trial lawyer would wish, when we met, Mark said, no, I want to stand up, and I want to get up in front. And so we're going to conduct this as an interview, but Mark wanted to stand up, and so I'll stand here at the podium, and he can stand there with his wireless microphone. So first I want to ask you, so you have such a diverse background, you've worked on so many different high-profile, important cases, then you get a patent case, and I don't think you had a lot of experience in patent litigation, but you get a case that goes from the Eastern District of Texas through the Federal Circuit all the way to the Supreme Court, a very significant patent case. So how does that happen?
Well, I have really devoted most of the last decade to pursuing this terrorism case. And it was pending in the Eastern District. It involved Americans who were killed in suicide bombings in Israel during 2000 to 2004. So I was in Israel a lot and really deeply involved in that when one of the people involved mentioned that there were some Israeli inventors who had a technology patent, and would I be interested? And I thought, you know, this is great. This terror case has been so depressing, so dramatic, blood, tears, destroyed families. When they mentioned a patent, I thought, oh, that'll be easy. It'll be, you know, it'll probably take a year or two, and, you know, it won't be controversial. It'll just be plain vanilla. Well, that was 8 years ago.
Well, so given your background and all the experience that you've had in different types of cases, how do you compare your experience in a patent case at the trial court level, we'll start there, to your experience in so many other cases in terms of your trial experience?
Well, back then, and I tried the case with others to a jury twice. I really didn't understand things in the first trial. So consequently, I thought it was just like other cases. I didn't know that, they hadn't even figured out what the right burden of proof was, that there were all these things that I thought were just taken for granted that were very unsettled. But I felt it was very much like a normal business case. Voir dire, pick the jury, opening statement, cross-examination, themes, visualize. I thought it was pretty much the same, but I learned that it was different.
So and part of the idea here is I'm going to just encourage Mark to tell stories and get out of the way, but what unique challenges did you confront at the district court level in your patent case?
Well, the biggest challenge was not understanding the law and not having brought in a real patent specialist at the time. I later learned what great value that would bring. And I thought the key was all about, the technology and persuading the jury. At this law school many years ago, just down the hall, I was taught by an adjunct professor who said in trial tactics, win it in the trial court and worry about appeal later. That has cost me several $100 million and meant that I've had to try a few cases more than once.
Well, you did have to try this case more than once, so go ahead and explain why did that happen? What gave reason for having to try at the district court, to the jury, the case twice?
Well, everything I'm going to say, I'll say this was the judge's perception. I don't want to say it any other way, but a lot of our witnesses were Israelis who had come from Israel, some with a heavy accent. The investor in the patent was an Israeli who was Jewish, and that all came out in some sort of normal way of who these witnesses are, where it was the invention took place, and the like. And in the course of the trial, I think the other party got unhappy because one of the Israeli engineers who they thought was going to be available had gone back to Israel. And so in a little bit of a press on that, they asked the key plaintiff, who was Jewish, he goes, when was the last time you saw, Chaim Barak? And he said, well, I had dinner with him last night. Well, where did you have dinner with him? He said, the Bodacious Barbecue. And the lawyer shot back, I bet you didn't have pork. And that really incited the judge, who felt like, along with other things that occurred at the trial, and the opinion reflects this, that the defense was really playing on local prejudices, and there had been other comments. I won't take time to go in them, and they're in the opinion. But the judge was very offended by that, and ultimately, because of it, granted a new trial, and that's what led to the second trial. The damages, by the way, in that first trial were $4 or $5 or $6 million, but that was far less than we were seeking. I think that was a verdict that I wasn't wanting regardless to go up, and so we had the opportunity for a second trial where I learned a lot more about patent law. And that resulted in the $74 million verdict, but apparently for the Federal Circuit, it wasn't enough patent law.
Well, yeah, before we get to the Federal Circuit, and we'll talk about that, but what is your takeaway? Let me ask it this way. What could a patent litigator learn from a non-patent litigator?
I'm not sure at this point much. I had been told, and I think this is real archaic information, that, there are these patent, I think maybe it was Chief Judge Michel says, the patent nerds. I've been told, there are these patent people that are real smart and they know all the technology, but they're really not the person you want in the courtroom. And then there's all these, brilliant trial lawyers, and they can go with it. I mean, my experience was that there are a whole lot of very good, smart trial lawyers, patent specialists, and there wasn't much I could teach them. They were extremely formidable adversaries. I think the way we are educating ourselves now in CLEs and the like, whoever's going in the courtroom, whether it's a patent case or an antitrust case or any other kind of case, know that they have to be skillful in the art of trying a case. And I ultimately learned you've got to work with patent lawyers and become skillful in what patent law is all about.
Well, talking about expertise in patent law, so patent cases are unique in the sense that they go to one intermediate appellate court, the federal circuits, right? So your case gets appealed to the federal circuit, and then I would call it a split decision, but ultimately not in your client's favor. But there was a split panel decision, then you seek en banc rehearing, and you come very close to a grant of en banc rehearing. I think the vote was 6-5. Very close. So I would say mixed results of the federal circuit. It's going to lead to the Supreme Court, and we'll really focus on that. But at the federal circuit, because it is a unique court, how would you characterize your experience, and what did you learn about the federal circuit itself and practice in front of that particular court?
Well, again, this is supposed to be the non-controversial case that now has the court split 6-5 and all other kind of problems and new law and changed jury instructions. One of the big issues, the jury had been instructed on induced infringement, beautifully in accord with the law at the time, but a few weeks or a month after that verdict, then the Global Tech case came out. And there were other things that were done right at the time, but there were changes in the law because the patent law is so unsettled. I would say at the federal circuit, and then it became even more so at the Supreme Court, is sort of getting over the awe of it all. I mean, I've argued a dozen appeals, I guess, over my career, not that many. But, you know, I kind of had the gist of it. But it was the awe of it. You know, there I am. There's the White House right around the corner, and, you know, you're preparing for a few days, and, you know, and you're Washington, D.C., and you walk into to the grand building, and the White House is right there, and that can be very, you know, disconcerting. And you have to overcome that and be ready for the penetrating questions. It was different where you don't know, at least at the time, who's on the panel, and you find out at the last minute, and that can change the dynamics of everything. But I would just say that I started to realize there I had to overcome the majesty of it and go in there prepared and focus on the questions. And I was up there, as I was at the Supreme Court, with an extremely strong adversary in Bill Lee, who was on the other side. And this got repeated at the Supreme Court when Seth Waxman was on the other side. You know, I'm sitting there scared as hell, and they come in, they're hugging everybody and, you know, putting everything down. I can barely, you know, stand up there. And so, you know, that kind of being able to leave Dallas and do what we need to do up there was something that took time.
Well, so you have to file a petition at the Supreme Court, right? So you're at the federal circuit, your petition for en banc review narrowly fails. You decide to file a petition for certiorari from the Supreme Court, and you present two questions to the court. And we're going to talk about the substance of the patent law, at least maybe a little bit. But for now, I want to focus on a little bit of the procedure. So Cisco files what they call a conditional cross petition, but ultimately the Supreme Court asks for the views of the Solicitor General as to whether they should grant cert in the case, which is something that happens often in patent cases. So I want to focus on that process. So they request the views of the Solicitor General's office, and then you get to actually go and present your case to the Solicitor General's office. So describe that for us.
Well, as I get to that, David, I would say that, you know, to illustrate how I made so many mistakes and stumbled my way to the Supreme Court, I was thinking we shouldn't even file for cert because it was such a long shot to be granted. And I'm really glad, obviously, that we did, not only for the good outcome there, but, you know, the opportunity to appear before that court. But first thing that happened after we filed for cert was the court seeking the views of the Solicitor General. I mean, I had to look that up and figure out what that even meant, but In the terror case, right about the same time, where we didn't want the Supreme Court to take the case, they had solicited the views of the Solicitor General, or sought the views of the Solicitor General. So I was starting to figure out what that was all about. And, you know, I understood that it was very important to get the Solicitor General on our side. And I learned that the Solicitor General is the lawyer for the government, and they will poll the appropriate agencies and largely take that position before the Supreme Court. In the terror case, it was very complicated because it involved the Antitrust Division and the Treasury and all others for some issues that were before the court in that case. And I had been to the conference room, which I ended up being at in the patent case with some of the same, you know, people in the Solicitor General's office. But the first place I went was to the patent office, and they were willing, as I think most of the agencies are, to allow the parties to come in separately and have a conversation about the case, ask questions, and that's what was helpful. So I went to the patent office, and again, I didn't know where I was going or where it was located, or but it was cool, you know. I mean, it's pretty cool, and and they're talking all this policy and stuff. And from that point forward, I mean, so much of it, if not all of it, was policy issues. I mean, they didn't really care about what this case or that case, you know, it was about what was the right policy. And I could sort of tell the government, they don't typically just open up and say what they're thinking, but it was kind of clear that they didn't like this holding of the Federal Circuit that a good faith belief in invalidity should be a defense. It was pretty clear they didn't like that, and so we kind of had a good conversation about why that was bad. The next thing that happened is that the Solicitor General said, you know, come to Washington if you want and discuss with us. So they had Malcolm Stewart, the head, I think, of patent area, among other things, in the Solicitor General's office, and the patent office people came. And again, they're not really telling you where they're coming from, but they end up writing a brief, which is probably, I mean, that's the amicus brief that I was concerned with, not all the industry briefs in general. And so they wrote a very strong and compelling brief as to why the court should take the case and rule the way I wanted, which was to say that that was not a defense, that a good faith belief in invalidity was not a proper defense. So that happened, and the court said, come argue it. So that was a happy day.
Yeah, I bet it was a happy day when you found out the Supreme Court asked you to come and argue the case. The first thing you have to do, though, is file your briefs, your merits briefs. So you file the merits briefs, and then comes a second deluge of amicus briefs, right? So something you probably don't experience at the trial court level is any amicus briefs, but at the Federal Circuit, there were amicus briefs. And at the Supreme Court in particular, the Supreme Court really values amicus briefs. And anyways, there's so many amicus briefs filed in patent cases. There's rules, right? You can't pay for someone else to write or file an amicus brief. You cannot author the amicus brief if you're representing one of the parties. But I guess you could solicit them. But anyways, how do you handle that, this idea of all these amicus briefs coming in and the lack of control in that regard with regard to all the arguments that are coming into your case?
Well, I enjoyed it because they were all color-coded, so it was very nice across my desk to have all the yellow ones over here, all the orange ones over there. And in this case, at the very beginning, it was suggested we need to run out and get amicus briefs. And I think we concluded that we weren't needing to do that. We just, you know, there were going to be plenty, and there were, you know, like 8 or 10 on both sides of it. You know, big pharmaceuticals, generic, all the different interests, technology, even where my daughter worked, they were against me, but I didn't let that bother me.
Well, I want to ask you mentioned this earlier. So your adversary at the Supreme Court was Seth Waxman, former Solicitor General of the United States, with significant experience arguing cases in the Supreme Court. And this is your your opportunity to argue the case. And very often in patent cases, there are people out there that have experience in patent litigation and at the Supreme Court, and very often the trial counsel will get replaced, but you didn't, your client stuck with you. So good for you, but I'm curious about that process and the thinking that went into that.
Well, yeah, it did take the client making a hard decision maybe. I mean, Seth Waxman, I think that was his 73rd argument before the Supreme Court. He made sure everybody realized that. And, you know, by the time the day came in the Supreme Court, I mean, I was like wired up, you know. I mean, it had been, and I had been to the court for hearings a few times to sort of settle down, and had been doing moot courts at law schools and with the help of former Supreme Court clerks and patent lawyers and patent professors, and all that was very helpful. But still, when the morning came, I was very nervous. And there's a little lawyer's lounge, you know, that you get there, and then the hearings were the first case up at 10, and the clerk of the court with the long tail, you know, tuxedo, long tails, and leads you in, and I met Seth Waxman in that lawyer lounge for the first time, and it was sort of a quick handshake. I mean, you know, maybe on his part. So he had to go embrace all the people that he knew, and so I go in and I sit down at my chair. And, you know, he said he'd be in like 5 to 10. So I was there at 9:30, and there's a big clock up there, and it's 9:30, and I look up a half hour later, and it's 9:35. You know, that's how. And about 5 to 10 or 10 to 10, he comes in with this suitcase full of the briefs and everything, and he brings them in, and you know, I'm right next to the podium, and he's next to that, and he slams the books, and I jump when he, you know, throws the books down. But in terms of, you know, how all that came about, I mean, the client felt like, well, I knew the case. I would spend the 3 months doing nothing else but that, and I did. And, you know, it worked out.
It did work out. So the Supreme Court agreed with you.
Let me add one thing, David. I was trying to remember this. In the moot courts and things with these law professors and patent people and the others, right at the last, I think it was the day before, I said, you know, I don't really like to take notes up there. There's no way, because they had talked about, you know, 3x5 cards or manila folders and all these various things. And I said, you know, I'm just going to go up there to the podium, and I'll be ready. I have my opening sentence. I have my last sentence. I'll be ready for the questions. I don't think I'm going to take any notes. And I was told there's only 2 people that argue before the Supreme Court without notes, and you're not one of them. So I did have a little something up there. You know, and I was told to be ready, you know, for the justices to jump in right away. And, you know, we practiced all of that. And you might get 60 seconds, you know, if you're lucky, maybe 90. It never goes beyond that. And so you have your strong opening. I spoke the first sentence, and Justice Kennedy immediately asked a question. But I was so, later I was like, who is the justice that asked that first question? It was a little unclear.
Well, so if you take all of these experiences, right, so the case, by the way, is still ongoing today.
Yes, I'm really looking forward to the 3rd trial. And then, as Chief Judge Michel said, with the various, you know, motions and trial and another appeal, and I'm sure it's going to take another 3 years.
Well, do you have any overall views? So from taking the perspective that you have now from the trial court through the federal circuit to the Supreme Court back down with the perspective of another trial, and you're representing a patent owner here seeking to obtain a judgment of no invalidity, a judgment of infringement, and then a judgment of, you know, an award of damages. What's your overall perspective of the patent system? You maybe came into this case with a view of the patent system, but I'm sure your experiences have maybe changed that view or at least informed it.
Well, I agree with everything Chief Judge Michel said, so, but I guess in my own view of it, since I didn't have that perspective before, I really didn't like the uncertainty that existed. I was astounded that things changed that much on basic sort of things. That would be the overall impression. I think the other things can be managed. The cost is enormous with experts and everything else. So those things stand out.
Well, congratulations and good luck on the rest of your case. But by the way, on the substantive issue, lest we be faulted for not at least identifying clearly the substantive holding of the Supreme, because we've been focused on a lot of procedure here, really. On the disputed issue of intellectual property law, the Supreme Court agreed with Mark and his client and ultimately held in their favor, at least vacating the Federal Circuit's judgment, that a defendant's good faith belief in the invalidity of a patent claim is not a defense to a claim of induced infringement. So that was the substantive holding, but I wanted to make sure we actually included some substantive law in there. So join me in thanking Mark for his time today.